Well, everyone, this has been a really hard and disappointing day. I'm here with Raz. We're talking about how the appeal went, and I'll just start off by saying it didn't go well. In fact, it was surprising how poorly it did go. I'm sorry, we went in with a pretty strong case. Every indication was that it was strong. The lawyers said it was pretty strong. The situation was that we were partially funded by legal aid, and legal aid never takes an appeal unless it's fairly strong. But in this case, I went in and I encountered the most overtly prejudicial justices I've ever seen. And it was pretty clear within the first 10 minutes which direction they were going. I think me and Raz talked about it, and really it came down to the fact that they were defending the justice's decision, but in order to defend the justice's decision, they had to defend all the actions of NOPRAT. And as always, the disappointing thing is it's pretty much anything she does is justified and okay, and what happens to me is simply, hey, guys just have to take it. And it was disgusting and it was denigrating. And I think the real final kick was that they walked in and told the other side they don't even have to make arguments, and then proceeded to read from a clearly already prepared judgment. So it's funny, we were going into that court and arguing that the predisposition and the bias of the judge was an error, and yet here the appellate court was probably the most highest example of predisposition and bias that I've seen yet in the court system. So I guess we're going to have a quick breakdown of some of the things that the appellate court talked about. We might post some excerpts from it, but basically I'll just cover some of the really disgusting things that went on. So just to clarify, NOPRAT is the name of my ex, in case that confused anybody. So I'm just going to go through it. Now, first off, I was there with my lawyer, just the two of us in the courtroom. And her lawyer, funded by legal aid, and get this, legal aid is paid for by your tax dollars. And it's only supposed to be for residents of Alberta. My ex is a non-Canadian citizen and clearly a non-resident, as she's living in Thailand, and yet legal aid continues to fund her lawyer. But here's the amazing thing. Her lawyer comes from what's called the family law office. Now, one of the concerns of the court system is balance of power. And I'll tell you, the family law office creates one of the hugest imbalances of power in family law. They are misandrous, they're practically all female in terms of staff, and they represent almost all females for clients. They are a very misandrous feminist organization. And this has been evidenced to me by the many, many times that her lawyer has walked into the courtroom, and sitting behind her is a cabal of feminists and lawyers, always coming with her. Today it was 8 people, 2 of whom I recognize are actually lawyers who work at the family law office. Now, isn't this interesting? Family law office lawyers are paid a salary. They're not paid per hour like other lawyers have to earn it, and they don't have to have a certain number of clients to maintain or anything. This means if they have a complicated case, they can devote huge numbers of hours to that case if they choose, and if their manager okays it, and if it's defending a woman, it will almost always be okay. And so then they can go to work on this. Not only that, but there's a lot more articling students working at the family law office, and there's the family law office representative to help the client. Getting private practice law lawyers, you don't get any of this support. And private practice law lawyers have many issues. They have to maintain a certain number of clients to make enough money to run their law offices. Furthermore, they have office managers who often tell the lawyers that, hey, you can only devote so many hours to legal aid cases because we got to make the big bucks and get the clients to pay a lot more. Legal aid pays about 1/4 to 1/5 what a lawyer normally makes hourly, $80 versus $400 or so. So I always find it disgusting and a huge imbalance of power creator, the fact that the family law office lawyers, funded by the taxpayer, they always seem to have so much additional help that private practice lawyers don't. Unfortunately, my ex got the family law office lawyer, which isn't surprising because they primarily represent female clients. But today we had a little feminist cabal of lawyers and articling students and secretaries, all from the family law office. So that's your tax dollars at work, instead of having one lawyer there for her, which really shouldn't even happen because legal aid does have a mandate to only fund lawyers for residents of Alberta. They're funding all these people to sit in the gallery and observe. Way to go, taxpayer dollars, to work to keep my kids away from me in Thailand. So that's always pretty disgusting. And this was, as usual, her little group there. I would suggest that you should start looking or talking to your MLA about asking how come your tax dollars are paying for a Thai citizen, for her lawyers and all of her legal fees over and over again throughout this entire conflict. Your tax dollars have paid for her lawyers, including an immigration lawyer to help her stay in the country. I could go on about this. Should I, Raslo?
Yeah, why don't you go through the details of the case?
Sure.
What specifically happened?
The family law office is funded by taxpayer dollars. The lawyers have far more time than private practice law lawyers, and the clients of family law office lawyers have access to a family law representative who helps and supports them. They also have a lot of articling students. The involvement of the family law office creates an imbalance of power in any family law judicial dispute, because these lawyers have far more time to devote to complicated cases. If it's a simple case and you can afford a private practice law lawyer, you're probably okay. But if it's complicated, most private practice law lawyers don't even like to go up against family law office lawyers because they're aware of that imbalance of power. And they're very concerned that they're going to get their butts kicked because they simply cannot devote the kind of hours, unless you're very rich and can pay them a lot. They can't put in the time that the family law office lawyers can. The mandate of legal aid is to only fund Alberta residents. My ex, Noprat Ramasut, the Thai citizen and the non-resident, has actually been funded by legal aid since the beginning. You should really go to your MLA and complain of this, because what happens is the legal aid is always complaining that they're unable to balance their budget. They operate at a loss, and so they're often unable or unwilling to take many cases on, and many of these cases are Alberta residents. Many of these people are men who are very much in need of legal support. And yet, because your tax dollars are funding non-citizens and non-residents of Alberta, particularly when they're immigrants or newcomers to this country, then there's no dollars left for Alberta residents to actually get the support and the help that they need. As I mentioned earlier, the appeal was very disappointing, and let me talk about some of the reasons why. So first of all, within the first 10 minutes, it was pretty obvious where things were going. My lawyer presented the case that my ex had moved the kids several times and moved into a shelter, and he was trying to discuss the fact that this should not have occurred. That sure, if she wants to go and seek shelters and stuff like that, she can, but really she didn't have grounds, and she certainly didn't have the right to simply pull the children along with her. Well, almost immediately, Justice Conrad, the justices were Conrad, Slater, and O'Farrell, Justice Conrad, the older lady among the group, immediately started to challenge and say, well, any woman who goes into a shelter has to take her children along. More or less, how can you expect women not to? The funny thing about this is that, men have no place to take their children. If they're in a domestic abuse situation, which I certainly was, there is no shelter for me to take my kids. And so we have the typical double standard. We're all crying and sympathetic about poor women. If they go to a shelter, they have to take their children. They have to remain as caregiver. And yet, not for one moment was it ever discussed, where do guys go? Where do men take their children? Because there is nothing for men. And this is exactly the kind of double standard that just churns my stomach. And for some wacky reason, these highly educated, highly articulate, highly trained and educated justices can't see the hypocrisy in this. Not once did the judge even pause between breaths to say, oh, but, guys face the same problem. No, it was all sympathy for my ex. It was all, well, how can she go to a shelter and not take the children? Our argument was this wasn't in the best interest of the children because taking them to the shelter pulled them out of school. All of a sudden their attendance and their grades plummeted. So clearly it wasn't working out for them. And yet that was never discussed by the justices. All they wanted to talk about was how my ex was inconvenienced and how she had to take the children.
Talk about a bit for why did she go to the shelter?
Well, why did she go to the shelter? She went to the shelter, I think, as a tactic to gain sympathy and support from the court. You see, here's how it works, folks. often a lawyer will advise a woman to create conflict. So even though me and my ex could mostly parent the kids, even though we weren't getting along, we didn't have issues parenting the kids. Once my ex got into the court system, all of a sudden she cut off contact with me totally. And the wacky thing about this conflict was that she received a great deal of sympathy for being in the conflict. I received none. And yet she was the person who was generating the conflict. She wouldn't communicate. She moved the kids 3 times. My daughter was running away to my house, and it didn't seem to matter to anybody. So she was actually the instigator and the originator of the conflict. She attacked me with the knife. I didn't attack her. And yet she gets all the sympathy and all the support. And this is what happens so often. And I believe that the reason she moved to the shelter was because, she didn't want to be near me. She didn't want to have contact with me. And taking herself out of the picture by lying her way into a shelter with claims of abuse was the easiest way to do this.
And there was no substantiated evidence of her being abused?
There was never substantiated evidence of her being abused. In fact, the affidavits we had from Thailand all basically said there's no history of domestic abuse or anything. The one big incident of abuse we have was her knife assault on me. And funny enough, we did try to press the charges of that, but the court wouldn't pursue it. She reserved her plea 13 times, and when it finally came down to 3 days before the trial, all of a sudden the Crown basically said, we don't want to go forward with this. Despite the fact that the evidence was pretty solid that she had attacked me with the knife not once, but twice, which a person in fear certainly doesn't do. You don't stick around and grab a knife twice. And we also had some very solid evidence of her breaking into my home and stealing documents substantiated by affidavits. And in fact, she took the documents that she'd stolen, swore them into an affidavit, and submitted them to the court. So what greater evidence do you need that somebody's broken into your house when they have dated documents and a sworn affidavit that had to have been taken from my house after she was locked out after attacking me with a knife? And yet, again, the court discussed none of this. And they just basically wouldn't hear it. During the trial, I tried to discuss these things, and the judge kept telling me, no, we don't want to hear about that. So I thought that was one of the errors. We would talk about the fact that the judge was discounting evidence. Well, the appellate court's discussion of this was justices have the discretion about the direction they want to go. And this judge wanted to only talk about the children, so the mother's conduct and stuff was, I guess, moot and didn't matter. Of course, if you're going to put the children with the mother, her conduct should matter. I think most reasonable people would agree on that. But I guess this particular judge felt it didn't matter, and the appeal court basically said his discretion doesn't matter. Judicial discretion is an interesting thing. And the appellate court often uses it to slough off making justices accountable all the time. Judicial discretion, judicial discretion, judicial discretion. Do whatever the heck you want. This evidence, you don't think it's good? That's okay. You think this evidence is good? That's okay. You can pick. It's your discretion. Doesn't matter that I had 10 witnesses in that courtroom, all of them saying I'm a great father, I take care of my family very well, I'm a good person, no history of abuse. No. The judge simply decides, I don't think that evidence is what I want to hear. But she comes in with only 2 witnesses, and hey, that totally carries the day because, he wants to believe those people. And he has discretion to do so. And the appellate court upholds that discretion. The other argument we made was bias. And this was the argument we wanted to win the day because our case had very strong evidence of bias. The typical bar to hit is, would a reasonable person see bias in this case? Well, when you have the justice making comments like when we discussed the fact that my ex had attacked me with the knife, he said, well, after she attacked you with the knife, why didn't you leave her and your kids in the house and you left instead of making her move into your mother's and share the kids 50-50? So let me see. A woman attacks me with a knife in front of my children, and he thinks I am supposed to leave her and my children in the house. What reasonable person could ever possibly think that this was right? You get attacked and you're supposed to leave. Not only that, but leave your children with a person who's been wielding a knife in anger and frustration and attacking. And yet this is clearly what the trial judge thought. Well, the response from the appellate court was that bias may have been shown in the justice's statements, but however, since it's a 10-day trial, that's perfectly ordinary. That as the justice goes along and he gathers evidence, that it's quite normal for his comments to begin to show bias as he's being swayed or swung one way or the other. So what the appellate court is saying is, hey, justices, it's okay to be biased as long as you have some evidence to base your bias, I guess. So, talking down to people, denigrating them, whatever, just go ahead, because if there's a little bit of evidence, and often that bias is just swung by assumption and prejudice, that's okay, because your history of evidence may indicate that, hey, guys are bad. So that's all right. Go ahead with that. We tried to talk about, my ex lying her way into the shelter, and they just basically said, no, she has every right to go into a shelter if she wants, and if she goes into a shelter, the children have to follow her. What are men supposed to do in that situation? I don't know. I mean, I'm shocked the justices can't see their own bias and presumptions in that. Speaking of presumptions, we argued predisposition of the court in the case of Justice Germain in the trial. And the funny thing was, this court was actually far more predisposed with many of their comments than Justice Germain was during the trial. Evidence of this was how they, initially argued that women can go into shelters. And one of the things was, we argued, they discussed the order of Justice Ho from provincial court, and they assumed that order had given her the parental right to move the kids into the shelter, when of course the order had actually given her no such right. That the order actually expected joint parenting and joint decision making was the order done by Judge Ho, and in fact my ex was in violation and in contempt of that order in moving the kids into the shelter because she changed schools, and the order stated explicitly that educational information had to be exchanged. So my ex got to be in contempt of an order, got to move my kids and do as she pleased without any repercussions from the court. And that was another discussing thing. The justices talked briefly about the spousal support. I was given $12,000 in arrears to pay for that instantly. And the judge's comment was that based on a 15-year relationship, which was actually inaccurate, it was 12 years, but based on that, I got off light at $12,000. So I guess the judges are saying that if you're going to be in a relationship with a woman, you're supposed to pay, and just accept that. So I guess I got off light because I only had to pay $12,000 for being with this woman for 12 years. So $1,000 a year I had to pay. Of course, the discussion of that I had to put up with her and her emotional and mental abuse for those 12 years, not to mention all the strife and conflict she caused, and not to mention the time she attacked me. I guess that doesn't count. I don't reserve any recompense for that. Never got talked about. We talked about credentials. They only talked about my credentials, basically stating that the fact I have a B.Ed and an MBA means that an imputed income of $50,000 is actually low in their opinion, despite the fact that my career teaching as a sessional instructor means I can only work at most 8 months of the year usually, and even then it's hard to find work today. That didn't matter. I should be able to make $50,000 quite easily, and if anything, that was a low imputation, and I should just be happy that he let me off that easy. They never bothered to talk about the fact that my ex has a bachelor's in nursing and a master's in psychology. Didn't even come up. We talked a bit about ability to work, an opportunity to work, and once again the court basically just said, well, you can work, she can't. I had a responsibility to sponsor her, despite the fact that legally we're not in a relationship, I can't sponsor her. They just glossed over that and said I should have done a lot more to support her, I should have sponsored her, I should have done all these things for her. And yet on the reciprocal side, they basically glossed over the fact that she offered no evidence that she was seeking work. She offered no evidence of making an application under the skilled workers program, to stay in Canada, to take care of the kids. None of this. So, it was really disgusting. We tried to argue that none of this was in the best interest of the kids, that basically what the court had done was attach the children to her, and then once attaching the children to her, basically anything she did or said was in the children's best interest. It wasn't discussed that the children were far more likely to have a better lifestyle in Canada than in Thailand. It was never discussed that the children had actually grown up in a Western lifestyle. And basically all the talk was about her. So, that combined with the little cabal that her lawyer had there, it was very disappointing. And essentially it ended up with the judges adjourning for 10 minutes. And when we returned, they said the other side doesn't even have to make arguments. They'd come to a unanimous decision and then read from a already prepared document that basically said, nope, no errors by the justice in custody and access, no errors in the financial awards, nothing. And it was pretty much clear, it was preordained right from the beginning, it was predisposed. Once again, it was based on assumption and presumption. Once again, it was based on only sympathy and concern for the mother, no concern for the children, and certainly absolutely no concern for me. My only job in this whole thing is to recompense her for the years we were together with spousal support. And my only other job is to pay for her to take my children away and take care of them. Because it didn't matter. The appellate court pointed out that the trial judge did say that we were both good parents, but supposedly her situation, this poor girl, you know, with her bachelor's in nursing and her master's in psychology, she can't get a job. She can't do anything. The poor girl has to go to a shelter, so of course she has to take the kids. No acknowledgement that I was suffering, that I was struggling, working very hard, that her actions damaged my career, damaged my income earning potential. None of that even appeared on their radar. And when we tried to talk about it, they didn't even seem interested to hear about it. It was very frustrating. It was terrible. I feel so bad because this should have been a case that could have helped so many, and it hardly even got off the launch pad. And I never suspected this. I never thought that judges could do this. Once again, simply, glossing over everything that happened to the man's side, glossing over what's really in the kids' interests, not even seeking to look at the full evidence, not even asking the questions or listening to the relevant answers. They're just not interested. They come prepared, their decision is done, and they're not going to be swayed, especially not when it means criticizing or making one of their own accountable. Hi. Hello, Internet. So, I'm just flipping through one of my 3 photo albums here that I got in Thailand. I finally got to go and see my children after nearly 2 years of not seeing them, and it was fantastic. It was a lot of things, but more than anything, it was just so good to see my children. I have wonderful pictures and videos of us being together and playing together and doing things together, and it was so great. It's so nice to say that one of my greatest fears was that after such a long absence, so many men told me that when they finally did get to see their kids again, that they didn't have the chance to be a dad ever again. And I was terrified that I would go to Thailand and just be like a visitor. And I'm really happy to say, and I think it is an amazing tribute to just how good of a father I was, that I was dad again instantly. That my kids shared secrets with me. They talked to me about life. They, when I said things to them that I had to, talk about hard subjects with them, when I had to discipline them, I was dad. It was dad all the way through. There was no ambiguity. The respect, the love, the honor, everything was there right from the beginning. It was great. And I have to say it was a disappointment in the way that I did try to work with the Canadian courts before I went to try and arrange a fair schedule, but just as I had forewarned the courts, I knew her lawyer would stall and make problems, and that's exactly what she did. I'm flying halfway across the world to see my kids at enormous expense and time, and her lawyer's arguing that, well, you have 120 days in Thailand, maybe you can take it in pieces. You not all at once. And the actual judge sat there, and rather than stop her on this bizarre, illogical, totally lacking common sense direction, the judge actually says, well, the order doesn't say it has to be 120 straight days. Just ridiculous. a good judge would have shut her down instantly on that and just said, no, it's not practical that this guy flies across to the other side of the world 2 or 3 or 4 times a year. But anyways, what I did is I did my best to work with the courts and with her lawyer, and it became obvious that they were not going to cooperate or do anything practical or logical. The chance for a ticket came up, and I just went. And that was one of the smartest things I did. I just showed up. The first thing I did was I went to the Canadian Embassy and forewarned them that I was in the country to visit my kids, and that my ex, Noparat, had threatened my life if I arrived in Thailand to see my kids. There is affidavits of people who overheard her saying this before the court, but they just continually ignore it. So I then went to Chiang Mai, the old city I lived in. There's some great support from there because there's a lot of people who love the children and care about me and the family. These people have been totally cut out of the children's life by their mother since she got them to Thailand. People who were there when my children were born have never seen or heard from them since the mother got them. And so I reconnected with them, and they gave me some great support, and I was off to Kampang Phet, where my children were, very quickly. And I arrived, immediately reported to the Kampang Phet police station and told them why I was there and about the threat, and they arranged very quickly for us to meet the next day. And that's where the story takes an interesting turn, because the next day me and Noparat met at the police station, and I had a lawyer from Chiang Mai on the phone to assist me, and Noparat, of course, had one of the wife of one of my daughter's teachers there to support and help her. And of course, she tried to play victim right away. Oh, she's terrified, I'm going to abscond with the children. You know, the wacky thing about that is she's the only one who's ever moved the children without notice. I've never done anything like that. And yet, it's such a nice victim story. And she knows how to play the victim amazingly well. And it makes such nice press, and everybody's worried about it. But you know what? The Thais didn't buy it for a second. And they were very adamant with her very quickly. No, this is the father, he has equal rights. And so we worked out a schedule. I get 5 days, she gets 2, which was about the minimum that I would have thought was fair or reasonable. And that's what was set up. So that very first day I went to my daughter's school. One of them is in Wachrawitya in the high school there, and she was so happy to see me. It was just wonderful, and I think I can share a picture with you of that very first meeting. That's me seeing Vanek for the first time in nearly 2 years, and you can just see the smiles on our faces. We're just overjoyed. And next I went to Patama School, where I met my son and my other daughter. And what was cool about that is my youngest daughter, literally ran across the school ground, threw herself into my arms. Like, she jumped and literally almost knocked me over. And my son quickly followed, and within moments I was walking around the school carrying both my kids. And now all the kids at Patama Darwinwood School think I'm like Hercules, because I was walking around for like 5-10 minutes with these 2 fairly heavy kids in my arms. And here's a picture of that little meeting. And again, you can see from the smiles, we are just overjoyed to be with each other again. And I brought their favorite stuffies to give back to them, because, you know, I never got to say goodbye when she took them out of Canada. She just took them. And the courts never made her, you know, have to tell me that she was taking my kids. She just got to do it. Isn't that amazing, eh? The courts didn't even have the humanity or the decency to order that she has to inform me if she's moving the kids somewhere. Way to go, Justice Germain. So anyways, the kids were overjoyed to see me, and it was awesome. You know, I need to tell everybody out there who's supported me in this appeal, thank you so very much. It was a shot, and you know, it didn't work out like we hoped, but I'm not giving up. I've been to Thailand now. I've seen my children. I've talked to them. I know for sure what is in their best interest. I know what they want. I know what's going to make them happy and give them the best life. And I'm not giving up on them. And I ask, please don't give up on me or them or the men's rights movement. We're all so important to making this work. In my case, some things you can do These are Canadian children. They are being abused by their Thai mother. They're unhappy, they're miserable, they want to come back to Canada, but nobody's fighting for them and the courts won't listen to them. Canada ratified the United Nations Charter of Children's Rights. That charter says that children have to have a voice in their futures. Our courts, our lawyers, our judges are not giving them the chance for that voice. Talk to your MP, talk to the Canadian Judicial Council, talk to your MLA. Tell them children deserve a voice in their futures. The courts have to start listening to them, because right now the system is the children talk to psychologists, they talk to children's lawyers, and all these people are biased by the feminist training and the background they get. You have to help women, poor women, women are the only ones that matter. The children know. The children want both parents. This needs to be heard. The United Nations Charter of Children's Rights, and Canada ratified it, says that children have the right to speak, have the right to be listened to, and have the right to both parents. Some other specific laws you can tackle. Go to your MLAs. Ask them, why is your legal aid department in your province funding foreigners? Why are your tax dollars paying for foreign mothers to take children away from Canadian fathers? This shouldn't be happening. One other thing I want to talk about. I couldn't see my children for one entire year when I wanted to, because the maintenance enforcement programs take people's passports away. And my passport was taken because I couldn't afford to pay my child support. They took my passport, which is the only means I have of seeing my children. In doing so, they cut off my access to my kids. The United Nations Charter of Children's Rights, Article 10, says that no state shall inhibit the travel to or from or through the nation state if the purpose is for family reunification. Canada ratified this charter in the 1990s, which means any MEP action to take away a person's passport when that passport is needed for family reunification is a violation of international law, and because Canada ratified that international law, it is in violation of Canadian law. I've tried to talk to my MPs about this. I've tried to talk to MEP about this. They all simply brush me off. I would like to see everybody write to your MPs, your MLAs, write to everybody and say, you cannot take a person's passport if they need that passport to see their children. That is just wrong.